Hi, my name is Lauren Ellerman, and I'm a plaintiff medical malpractice attorney serving Western Virginia. Now, plaintiff means we represent normal people. We don't represent the hospital. We don't represent doctors. We represent the patient. And we investigate and evaluate hundreds of calls every month as to whether or not the bad care someone received reaches the legal level of medical malpractice. Now, here's just a little bit of advice. If you've had something really bad happen, I usually call them a healthcare trauma, and you want to know whether or not there's a legal recourse. There are 5 very important pieces of information that you must gather before you call a medical malpractice attorney like us. And the reason we're doing this video is so if you call a couple people and you don't have this information and you feel like they're not being very helpful or responsible, or responsive to your call, it's probably because this very valid and important bit of information is missing. So number 1, you need to know the name of the doctor or the hospital that you feel provided the bad care. Sometimes it's the name of a nurse, but for the most of the part, it's a doctor. Now, I know not a lot of people know the name of their anesthesiologist or their surgeon, but if you don't know, call and ask. Call the place where you had the appointment. Call the hospital and say, I'd like to know the name of the surgeon who performed this. Or hopefully when you're getting medical care, write that information down. So number 1, it's really important to know the name of the person that you're calling to complain about, because we, as human beings, also need healthcare. And sometimes we might have next door neighbors who are doctors, or we have friends or brothers or sisters who are in the healthcare field. And so we might have a short conflict list of doctors in the area that we do not evaluate cases against. I know that's the case for our office. So if you don't know the name of your doctor, I can't fully perform any kind of investigation on your behalf. So number 1, know the name of the doctor. Number 2, know when it happened. So under the law, there is a statute of limitations as to when you can file a medical malpractice case. And in Virginia, it's mostly 2 years, not from the date you felt bad, not from the date you realized they did something wrong, but from the date of the bad care. So we often will get a call that says, well, I didn't know that 4 years ago, this surgeon did something bad and it caused my child harm, or I didn't know it was malpractice until this new surgeon looked at my x-rays and saw that it was malpractice. Doesn't matter. 2 years from the date of mistake, not from when you learned about it. So we need to know exactly when the mistake happened or the alleged mistake so that we can evaluate your case in a timely manner and in keeping with the statute of limitations. Number 3, we want to know what bad thing happened as a result. If you get bad care, but then you're fine, you do not have a medical malpractice case. You might have a complaint, you might have, something to file with patient advocacy, but you do not have a legal malpractice claim or a medical malpractice claim. There has to be some significant harm caused by the bad care. So if you're just kind of angry about it, and I get that, or disappointed, then you probably don't have a medical malpractice case. You probably just have a complaint with the hospital. The number 4 thing we need to know if you're calling our office or any other medical malpractice attorney, when you call about a medical malpractice complaint, is who do you think the bad apple is? Meaning, where in your care do you think the bad thing happened? If you were taken to the hospital by the ambulance and then the emergency room saw you and then you're admitted to the hospital and then something really terrible happened, who along that chain of medical care do you believe was negligent? And that will help the medical malpractice plaintiff's attorney really investigate the root of the issue quicker. We'll know which records to request first, where to focus our attention. But if you just say, well, gosh, these 27 people provide care and I don't know who did it, it makes our job, it's no problem. We do it all the time, but it makes it longer. And so if you have a gut feeling, and doesn't always have to be right, as to who caused the negligence or who was the bad care provider, we would like to know that information. And last of the top 5 things that you'll need to know before calling a medical malpractice attorney is the state in which the bad care happened. You need to call a lawyer in that state. And I know there's some great national firms that advertise on TV and advertise on the internet, and it's tempting to call a bigger, maybe a firm in Chicago or maybe a firm in LA, because you think those lawyers are probably smarter. They may be very smart, who knows? but they are not licensed to practice in Virginia, which means they can't file your case here. They then have to come get someone like me to file your case locally. And then what you have is a big firm in California that knows nothing about Virginia law advising you when it's really smarter to hire a lawyer in the state where the bad care provided in the first place. We often get West Virginia, Tennessee cases where clients will live in Virginia, but their bad care was in West Virginia, or they live in Virginia, but their bad care was in Tennessee. The state law that applies is where the bad care happened, not where you lived. So if the bad care happened in Tennessee, I'm going to send you to a Tennessee lawyer. If the bad care happened in West Virginia, I'm going to send you to a friend who is in Princeton. If it happened in Virginia, we want to help. So hopefully that'll give you some basic information before you call a Virginia medical malpractice firm. Thank you so much for listening.